Hey guys, what's up? Nothing new to report on anything. So I guess we'll just go ahead and get started. It looks like the state is going to rest and the defense is going to start today. And I am by myself apparently. So, replay crew, I love you guys. And if anybody is lurking, although it looks like I'm alone, um, welcome. And I'm sure my OGs will show up as they always do. So, let's take a peek and see what's going on in court. I always forget to share my screen. I want to just jump over onto the trial.
When examined on cross-examination, acquittal on both counts, I will work.
Actually, Mr. Hendry will be making the arguments.
Right, I'm doing now. Sorry, I was setting my computer up.
The sound gets.
Your Honor, this time the defense moves for a judgment of acquittal on both counts. I will work with the kidnapping charge first. The state's charge of kidnapping. First, kidnapping is a specific intent crime, which means that at the time the alleged kidnapping took place, it had to be the intent to kidnap. And typically, the intent is to commit something else. So it's charged right now that the intent was to either further the commission of another felony or to harm or terrorize the victim. Now, as far as the evidence that has been presented in this trial about the kidnapping, we have essentially the two neighbor witnesses who presented any testimony whatsoever about the kidnapping. Both witnesses describe Kathy Griffith as angry. They describe her as, stomping around in the yard, throwing things into a car. The first witness described her swinging her arms around a lot, both away from Colin and as she approached Colin, and even up until she was so close that Colin could reach out and touch her. So at that moment, we have the testimony, which seems to align between both witnesses, that Colin grabbed his mother. She exclaimed, according to witness 1, "Let go, you're hurting my hair." Witness 2 did not hear anything. And then, although it has been argued that Colin dragged her into the house, the actual testimony from the witnesses was that the two went into the house. So if we pause it right there, at this point, we have what is arguably a misdemeanor battery. We have what could be a defensible touch on Colin's part, that he, in response to his mother swinging his arms in his face, reached out and grabbed her. And whether or not he had the right to do so, either way, it would either be a defensible battery or a misdemeanor battery. When examined on cross-examination, neither witness said that they heard Kathy exclaim anything about not wanting to go into the house. They did not see her fighting to not go into the house. They saw her legs moving. They saw her go into the house with Colin. And that moment is what has been alleged and the only evidence that has been shown of a kidnapping. So at that point, Mr. Griffith's specific intent to kidnap has to have been completed. We do not have that.
I think that one needs to be thrown out because the way the prosecution made it sound was like he grabbed her by the hair and drug her. I was imagining dragging her like from the end of the driveway all the way up by her hair, and that he drug her out of her shoes and her AirPods came out, and like I just imagine this long dragging of the hair into the house the way he described it. But the way the witnesses described it was like she was close to the door and he just like pulled her hair and then wrapped his arm around her and put her into the house. And the way the one witness described it, that she actually walked up the steps of her own accord. He just was pulling her hair. And to me, that's not kidnapping. So I don't like that charge. I don't think that should be included in this. I mean, it's bad enough as it is. I don't think that that charge should be included. But I don't know. That's just me, I guess.
That in this case, Your Honor, we have not heard any evidence that there was any fight on Kathy's part, any unwillingness to go inside of that house in that moment. We know she didn't want to be touched.
She drove
at that
over
time
there.
that she said that you're hurting me. We don't know if she was upset about him having his hands on her. We do know that he was touching her too hard, essentially, is the evidence that has come forward. And again, that would be a misdemeanor, which would not be sufficient in any case to charge a kidnapping with.
Yep.
So
Agreed.
we move on from there. What evidence have we heard in this case that is going to turn this from a misdemeanor battery to a kidnapping? Well, we ultimately have a deceased person in this house. We have, the fact that she is found in the house roughly an hour and 15 minutes after this incident occurred, with the yelling outside and the touch on the upper torso. And we have no evidence of what happened inside the house. We have no evidence that Kathy was not in that house, or wasn't in that house against her will, that she remained in that house against her will, that she was not able to move in that house. The only evidence we have of anything that happened inside that house is the body itself, with the forensic evidence that has come into play from that, and Mr. Griffith's 911 call. Mr. Griffith's 911 call states that there was an extended, prolonged fight, and that they ultimately, there's the accident that she fell on the knife. There is no mention that that fight started outside of the house, that it continued inside of the house, that it continued all the way up until the moment of her death. There is no evidence that she was dragged immediately from the porch into the house and murdered at that time, like the state may offer as an alternative. We have not heard that from any witness. We have not seen that in any evidence that has been presented. So again, the evidence of the kidnapping turns back to the misdemeanor battery, that she was touched, that she exclaimed upon the touch, and that she continued into the house without doing anything else to say that she did not want to go in that house. All of the case law on kidnapping gets into whether or not that the crime itself was completed, whether it was necessary to complete the other crime if there is another crime that's charged. But all of it, every case, includes proof that the victim was held or moved against their will. And we don't have that in this case. So we are not even at the starting point of whether or not you should consider a phase-on test or anything like that that falls under the kidnapping line of cases, because we have not heard a single piece of evidence that says that Miss Griffith did not go inside of that house willingly. So for that reason, we are asking for a judgment of acquittal on the kidnapping charge. As far as the first-degree murder goes, Your Honor, the evidence that has been presented so far of premeditation is that Mr. Griffith had a conversation with his grandfather in which he said that he wants to kill his mother, that he wants to slit her throat, according to the witness. We have the testimony from the officers who stated that he said things like he wanted to kill her. We have the testimony of Mr. Griffith himself in the back of the car where he said that he could kill her. Again, other than Mr. Walantis's testimony, every one of those officers, every piece of body cam footage, every piece of car footage that we've seen is conditional. That if violence occurs, if she comes at me against anything, then someone's right to self-defense. If it did, then every officer who ever acted with lethal force would be charged with a capital crime. They are trained to respond to situations, and they know how to respond to that situation. That knowledge does not create premeditation. The fact that Mr. Griffith thought about what he would do in a situation where he felt that he was being threatened, and even took it as far as to how he would do it, does not create premeditation. That is not a crime. That can still fall within the realm of self-defense. The only piece of evidence that we have that would go against that is that he didn't have enough marks on his body. I mean, the state offered physical proof that he had injuries. They have argued that those injuries were insufficient in opening. We have not had any witnesses testify to the extent of Colin's injuries, what could have caused those injuries, what could not have caused those injuries. In order for this to be a first-degree murder, we have to have premeditation, which so far I do not believe the state has proven, and we have to have a waiver of self-defense in some way. If there's just a waiver of self-defense, if this was a fight that got out of control, I apologize. Do you have to?
Just like John's school keeps calling up. I'm wondering if there's an emergency.
Yes, Your Honor. I understand. Escalated once. Okay, Your Honor, I was speaking as to the if this were a fight that got out of control and Mr. Griffith had started that fight, then this is arguably second-degree murder, as would be charged, that this was something that was created inside of the moment, that the decision to kill did not require adequate reflection, and that this would be a second-degree murder. So we have I don't believe that the felony murder should be considered, because I don't believe that the kidnapping is sufficient to reach that. And there's been no evidence that the kidnapping was a continuous crime. Again, we have proof of her injuries showing that there was some kind of fight. We have proof of Mr. Griffith's injury showing that there was some kind of fight. We don't have any proof that Mr. Griffith made a previous decision to kill in this moment, that this was orchestrated in any way by him. In fact, we have the opposite. We have Miss Griffith showing up at that house without permission to do so, being angry as soon as she gets there and never cooling off, according to the witnesses. At the time that she gets into his face, Mr. Griffith acts. From that moment forward, they go inside the house and it's unclear what happened. We have no evidence. We have no forensic evidence that showed what happened inside of that house to show that this was something that was planned, that this was something that was thought out, and that this matched any kind of a decision that Mr. Griffith had made. If anything, it is more likely that this fight escalated once the parties got back inside. This fight escalated, that there was at some point, someone gets a knife, and then Miss Griffith ends up dead. And to me, that is the realm of a second-degree murder. That is a standard fight that goes too far, and that is what the jury should be considering. They have not had any proof, again, that would rise to the level of premeditation. They have not had any proof in this crime that anything else would enhance this crime to a first-degree murder. This is a second-degree murder and a battery that happened beforehand. And it is arguably self-defense on either issue. But again, I will concede that by raising self-defense, we have created a circumstance where the jury has to make a finding of fact. So I'm not arguing that this entire incident can't be considered by them. I'm just arguing that it should not be a kidnapping and it should not be under the felony murder statute, and it should only be a second-degree murder.
Why isn't he arguing to just dismiss the whole everything?
From two independent witnesses we saw and we heard that the defendant grabbed Kathy by the hair. He did that forcefully. And what did he do? He dragged her / pulled her in against her will as she was protesting and yelling loud enough so that one of the witnesses could specifically hear from inside, looking out the window, "Stop, Colin, you're hurting me." At which point the defendant dragged her / pulled her into the house, which was clearly forcibly, which was clearly against her will. And then once he had her inside, of course, he confined and/or abducted her from outside into inside and/or imprisoned her. The last place that she would want to be would be inside after being yanked inside by the hair by her son, who has told multiple people, obviously, his intention to kill her. When he's furious, when she had just sent him the text message regarding the other person that he murdered by shooting that person in the chest and in the head, and when she threatened to come forward and tell the officials in Oklahoma and elsewhere about the defendant confessing that in fact was a murder, that it was not self-defense. So once he gets her inside, he has no prying eyes, he has no witnesses, and he can inflict anything and everything he wants to on his mom. So once she gets yanked from outside to inside, and mind you, he had her by the hair, which there's no way she could get loose from that. So as he yanks her inside, once that door closes, that was clearly the beginning of the end for her. Now he's all alone with her, with no witnesses and nobody that could help her. And his intent was to inflict bodily harm upon his mom, or to terrorize her, and or to commit or facilitate the commission of the murder. Judge, once the defendant gets her inside, there's not going to be an hour and 15 minutes of these two people talking and having a rational conversation. It was an absolute powder keg that went off immediately. So the defendant, as we come now to the first-degree murder, you can see the pathway by which the defendant pulled her by her hair, dominated her physically. He's 6'2", outweighs her by, who knows, maybe 30 pounds or so. He's bigger, he's stronger, he's younger. He had to go to the butcher block, take out the knife of his choosing, continuing on with the premeditation, and then stab her, not just any place, not just cut her, but stab her in one of the most vulnerable parts in the human body, which is right in the neck. And as we heard from Robert Willantis, the defendant accomplished exactly what he wanted to do for so long, which was to stab her / slit her throat, watch her bleed, and watch the life drain from her, which is exactly what he was able to accomplish with premeditation. So, Judge, I would rely upon the facts of the evidence and the whole record, and ask that you deny the defense's motion and allow the jury to consider both the kidnapping charge as well as the first-degree murder charge as we go forward, Your Honor.
Your Honor, as to some of the arguments just made, first off, there's been no evidence of anger in the moment on the part of Mr. Griffith. We have the evidence from the neighbor that he was calm, that Kathy was irate, that she was flailing around, and that he reached out, but that his demeanor did not rise. Like, he didn't start, there was no evidence of rage or anything like that. So I know the state keeps using those words. That's an argument on their part, but that is not the fact that has been shown in this case. As far as the decision to choose a knife, again, that's not a fact in evidence. As far as the decision to dominate her physically, well, we have evidence of bruising. So I guess I would concede that there was a physical altercation, and it looks like Miss Griffith bore the worst of that. But I don't know that dominate physically is something that has been testified to in any way. Again, this being argued by the state attorney. The size of Mr. Griffith that keeps coming in from the state's words, that he's 6'2", that he's some weight. We don't have any fact on Mr. Griffith's size. I mean, the jury has observations. They can see me standing next to him and they can tell that he's much smaller than me. And I'll tell you, I'm not 6'2". So I don't think that comes into play in a decision to, decide whether or not this was a premeditated murder. And as far as the kidnapping, again, the only evidence we have of Kathy's intent is when she shows up mad, when she's throwing things in his car. We have her intent. Yeah. And she had already gone into that house. I mean, she goes in, she comes out with stuff. That stuff was not sitting inside. So we have her not wanting to be pulled by the hair. But again, we don't have any proof that she was pulled by the hair. We have the autopsy of her body. We do not have a single shred of evidence that she was harmed in any way by a grasp to her hair. There's no bruising of her scalp. There's nothing like that has been shown. So she said, "You're hurting me," loudly enough to be heard. That's a battery. She did not say, "No, don't take me in there. I don't want to go in there. Stop." She was not dragged. I asked the witnesses specifically if her feet were going up the stairs, and they said yes, that she was moving her own legs, that she went into that house. So I understand the state's argument that they are making, but it is argument. They are not using the facts that have been shown. And the fact is that this is not a kidnapping. This is a misdemeanor battery and then a fight that happened inside, and that fight led to a death.
Taking the evidence in the light most favorable to the state, as I must, hearing on a motion for judgment of acquittal, I do find that the state has made a prima facie case as to each element of each offense. The motion is denied. Is there anything else we need to discuss before we bring the jury?
Judge, when do you usually do a jury instruction conference?
After everyone rests.
Okay.
Was there something in particular you
No.
wanted to address now?
No.
Are we ready for the jury?
I believe so.
He should have at least dropped the kidnapping.
So your daughter was Kathy?
Dang, I keep going too far ahead.
Raise your right hand if you sworn by the court.
Do you promise to or affirm that the testimony you give in this case will be the truth, the whole truth, and nothing but the truth? I do.
Ms. Detman, will you please introduce yourself to the jury and spell both your first and last name?
Susan Jetman.
Well, she'd already been in the house. That's the grandmother? Oh my goodness, she looks so young. But she'd already been in the house. She drove over there and went in the house. So how can you call it kidnapping? She went over there willingly. He pulled her hair and she said, "Stop, Colin, you're hurting me." She didn't say, "Stop pulling me into the house. I don't want to go into the house," because she was going in the house. That was the whole reason for her to go over there. She drove hours to get there. That was not kidnapping. Maybe legally it was, but I still don't think it was. Even legally, I don't think it was. I agree with his lawyer. That doesn't make sense that they charged him with kidnapping.
Susan is S-U-S-A-N, and Jetman is G-E-T-H-M-A-N.
Ms. Detman, how are you related to Colin Griffith?
I'm his maternal grandmother.
So your daughter was Kathy
Yes, ma'am.
Griffith, sorry.
Yes, ma'am.
So give the jury a little bit of an idea of who the other members of your family are. Who was Kathy's father?
Robert Volantis.
Were you married at some point to Robert Willantis?
Yes, we were married for 19 years.
When did you divorce?
We divorced in 1998.
After you divorced Robert Willantis, did you get remarried?
Yes, I did.
Who did you get remarried to?
Inaki Markovich.
And might need to spell that last name for the court.
A-R-K-E-V-I-T-C-H.
Ms. Detman, who are your children from your marriage to Robert Willantis?
John Paul Volantis, Kathy Volantis Griffith, and Christy Volantis Rooney.
Did you list them in ascending order of age, youngest to oldest?
The youngest.
Yeah. Okay. Do you have another child?
Yes, I do.
Who is that?
Kevin Markovich.
And that's from your marriage to Mr. Markovich?
Yes.
Now, Kathy, obviously Colin was Kathy's son. Did she have any other children?
Yes, she had an older son. He's still alive, Christopher Ray Griffith.
How old is he?
He is 24.
I want to ask you a few questions about Robert Willantis, your ex-husband. When you divorced in 1998, who got custody of your 3 children with him?
I did.
And since 1998, has Robert Willantis been a big part of your life?
No, except for the custody battles we went through.
What about, are you aware of his relationship with any of the 3 children that you had with him?
He didn't have a relationship once he was not granted custody of John Paul. He didn't want Kathy, considered Kathy to be damaged goods. He was only sued for John Paul.
Okay, but what was his relationship like with his children after the
He didn't
divorce?
have a relationship at all until Kathy divorced and she reached out to her dad.
When did Kathy divorce her husband and the father of Colin and Christopher?
2019, if I remember correctly. It was like December of 2019 when they filed. And I think it took a couple months for the divorce to actually take place.
Okay. Now, we saw pictures of Robert Willantis on a trip with Kathy. Tell the jury about that trip, what you know about it.
So Kathy wanted to meet the biological Robert's mother, the biological grandmother, because Kathy had many medical problems. So she asked me, she said, Dad said he'll take me to California to meet his mom. They lived in Anaheim. The mom lived in Anaheim, California, but you'll have to pay for it. And I said, okay. I said, just please try not to do anything too expensive. And I'll see what points I can use for the hotels. And fly over there. You guys don't need to rent a car. You can use your dad's car if it can make it to California. If not, we'll get a rental car.
So, Ms. Detman, did you in fact pay for Kathy to go on this trip with Robert Wolantis?
Yes. I paid for all the food, all the hotels, Disneyland, all of that.
And when was that trip?
That was before she got Colin back.
So before 2023,
Yes.
after 2019 though.
And after COVID was over with.
Okay.
So I believe it was 2022.
Are you aware of any other trips like that that Robert took with his other two children?
No, he didn't really have communication with them.
All right. So I want to ask about Kathy's funeral or celebration of life. Did the family hold such a thing for Kathy?
Yes, we had a celebration of life right here at the funeral home in Lakeland.
Was she actually buried or was she cremated?
No, she was cremated. She had conveyed to me as well as to her sister and brothers that she never wanted to be put in the ground. She wanted to be cremated and later taken back to the ocean in Key Largo and her ashes be put at the Jesus statue that we have under the water in Key Largo.
Has that been done?
No, we're going to do that this summer.
Where are Kathy's ashes right now?
Right now, they're at Christie's house.
Was Robert Wolantis invited to the celebration of life?
No, he was not.
Why not?
Robert tends to be very disruptive. He has difficulty with truthful manners, and we just did not want to have more lies and destruction. The final time that we could say goodbye to Kathy.
I'm going to ask you some questions now that may also be difficult. In the last roughly 2 months before Kathy died, what personal medical things were you going through?
So in the last part of June, I was diagnosed with stage 3 colon cancer. I had to have part of my colon removed and an ostomy put in place.
After you were diagnosed and had your surgery, did you have a fight with Kathy over Robert Wolantis?
Yes, I did. Kathy was very adamant that she wanted Robert to take care of me, that I needed to pay for his flight from New Mexico to Lakeland, get a hotel for him for 2 weeks, and get some sort of a car, and even pay for his food. And I told Kathy, I said, that's ridiculous. He hates me. I don't want to be hurt by him. Plus, has lost his nursing license. I want a real nurse that has.
Okay, hold on.
I'm not just object to all this collateral accusations.
Ms. Detman, as a result of you not wanting to follow Kathy's wishes as far as Robert Wolantis coming here and taking care of you, Did that cause a break in communication between you and
Yes.
Kathy?
Yes, she refused to talk to me. She blocked my phone. She told me if I came over to the house, she would have me arrested for trespassing. She said, you can contact Colin, but you can't contact me.
And that, okay, I'll move on from this. Mr. Wolantis on the stand mentioned that Kathy got Colin a second phone, and that must have been what Colin used to talk with Mr. Wolantis on the phone every week or every other week. Tell the jury what you know about a second phone.
The second phone, I purchased a second phone when Colin came to live with me in the January, February time period, the first time she threw him out. And I couldn't leave a kid in the double wide by himself without a phone. Plus, since I didn't
Well, wait, hold on. Why didn't Colin have a phone with him when he went to live with you in January of 2024?
Because Colin and I were at the Mexican restaurant in Port Charlotte. Kathy and Colin and I were supposed to go. When I got there, Kathy said, no, I don't want to go. And I said, come on, at least have some nachos or something. No, I don't want to go. And I said, can I take Colin with me? Sure. So while we were at the Mexican restaurant, she called me and she said, don't bring Colin back. I never want to see you or Colin again.
And the phone that Colin had at that point, where was it?
It was at Kathy's house.
Okay, so you brought Colin to
the double wide in Arvindale, and I didn't even have internet because, of course, I wasn't there all the time. So if I needed to, I'd hotspot my computer. I didn't want an extra expense for internet or cable or any of that. And so I realized I couldn't leave Colin here without a phone. So I told him, I said, we're going to have to go to AT&T and get a phone for you. And I even got a 786 area code because that's the area code that I have in the keys.
And that second phone, did Colin have possession of it from January of 2024 all the way up until September of 2024?
No. He only had possession of it for that small amount of time from when he came to, which would have been, it was either the end of January, the beginning of February. He had possession of it there. And then when he left, he took it, and I immediately got it. I got leaving.
Okay, I'm actually going to show you what's been marked as defense exhibit number 16 and see if you recognize it. Look at that and see if you recognize those messages from January 2020.
Well,
Do you recognize those?
according to this,
No,
okay.
don't read
No.
it. Do you recognize those messages in
No.
between you and Kathy?
No.
Okay. Do you remember there being a period in January of 2024 where where Colin was with you for several weeks and Kathy didn't remember that he had gone with you?
Yes.
And do you know what was going on with Kathy at that time?
She was suicidal, taking pills. She just didn't want to have her life. She was drinking
Okay.
excessively. She drank Everclear as her alcohol of choice.
Okay, Ms. Detman, just answer the questions, okay? You mentioned that she was suicidal in January. I'm going to show you what's been marked as Defense Exhibit 15.
I hate to even think this, but what if this woman did it to herself? Because it almost, she's so out there that she could have done it to get him arrested for it. I mean, that's what it sounds like. Like she's that out there. I wouldn't put it past her. I really wouldn't. Because on Ada K's channel last night, she was reading a document from their divorce. And one of the things that she threatened to do was call his school out in Oklahoma and tell them that he had threatened to bring a pew pew to school and use it in order to get him put in foster care out there. I guess so she could swoop in and bring him to Florida so he could be with her again. I don't know. I missed part of it, but I do remember hearing that part. I got there late, so, and I not had a chance to go back and read or listen to the beginning of the document. But that's not a mom looking out for the best interest of their child. That is a mother being selfish. So, and if she really is wanting to unalive herself, but at the same time wanting to get back at him because she wasn't the perfect little robot she wanted him to be or whatever, I could see her doing this on purpose to frame him for her murder. I hate to think that about a mother because mothers aren't supposed to do that. Mothers are not supposed to be that way, but I can see it in this woman. She's, oh God, how did this get to this place? Oh, man.
See if you those texts.
Yes.
Judge would like to admit Defense Exhibit number 15 into evidence.
Any objection?
No objection, Judge.
I don't receive.
Ms. Detman, Defense Exhibit 16 stated February 5th of 2024, and the blue text at the top was Kathy's number 941-258-0963.
Yes.
And were you the number below that?
Yes, ma'am.
And you mentioned the 786 number, but you had two phones, correct?
Yes.
Why did you have two phones?
I used one for work and one for personal.
So the blue message on top talks about Kathy just having been released from the ER for an accidental overdose. Was that one of the times that she had had a suicide attempt?
Yes.
So the phone that you bought for Colin in either January or February of 2024, and I'm sorry if you already answered this, but he didn't keep that after the brief period that he lived with you then, did he?
He went home with it and I had it back on the weekend.
Okay, so shortly after he went back home to Kathy.
Yes.
So Kathy, it sounds like off and on had estrangement from various family members.
Yes.
You mentioned that you and she didn't speak for quite some time after your cancer diagnosis. Had she cut other members of the family off at other times in her life?
Her and John Paul were not speaking.
Do you know why?
Yes. She got mad at his wife because the house wasn't clean to her standard. And Child Protective Services that Isabella was not taken care of, that she was in danger, something. I know DHS ended coming up to John Melantis' house. Of course, the investigation proved that there wasn't a problem. And John just said, I will never have anything to do with her again. She crossed the line.
Any other family estrangements from Kathy besides you and her brother John?
So Kevin and Kathy were supposed to go to Washington, D.C. together.
Kevin is your son with
Yes, and Kevin
Inaki.
and Kathy were pretty close. They were supposed to go to Washington, D.C. together because Kevin was in officer basic training in Virginia for the Florida National Guard. He just graduated from college, and he had time off during the 4th of July. And Kathy said, you know, it'd be great if Colin and I could meet up with Jean Paul in Washington, D.C.
Do you mean Kevin or?
Kevin, I'm sorry, Kevin could meet up. I was supposed to go because, of course, my cancer, I
Okay.
couldn't.
Miss Valentis, I'm sorry. I know you're nervous, but the estrangement, how
Yes.
that
So what
occurred.
happened is Kathy contacted Kevin and said, unless you help me get your father arrested, meaning Inaki Markovich, I don't want you coming to Washington, D.C. with me.
Do you know what Kathy was referring to as far as helping her get your husband arrested?
Yes, they had an altercation in our farm in Arcadia during COVID. So it was during 2020, around Easter time. It was before Easter. She threatened him with a baseball bat. And she said she was going to get her gun and shoot him. And my husband brought a shotgun out and said, I have a shotgun here. We're not going to be doing this. And later she said that he used the shotgun, fired the shotgun. And I said, it was a double wide. I think I would know if a shotgun had been fired in the ceiling in a double wide.
So after that interaction between Kathy and Kevin, were they estranged from each other for a while? But it sounds like she would kind of change her mind about who she was close with or wanted to have communication with. Is that?
Yes, because she called Kevin the next day and said, I'm sorry, come on to Washington, D.C. with us. And Kevin said, I already told my cadre, my leave's been canceled.
Okay. Are you aware of threats that Kathy had made to commit suicide?
Yes.
How many are you aware of, if you know?
Aware of 5.
Okay.
No, 6.
Whoa.
I'm going to show you what's been marked as Defense Exhibit 14. See if you recognize this.
Yes, I do.
Like to admit Defense Exhibit 14 into evidence, please.
Objection
No objection, Judge.
will be received.
What is this exhibit?
I wasn't sure if Kathy showed that to me. I wasn't sure if it was blood or a magic marker because I didn't see it physically. She said that it had something to do with a song she was listening to. And she was upset because of the divorce.
And you can't quite see it now, but did you see a video of, so you can see the triangle for play. Had you seen the actual video of this?
Yes.
In it, can you see what's written on the left side of Kathy's arm? I mean, you can't see it right now, but do you remember what it said?
I don't remember what it said because it was just so horrific that that she was doing this to herself.
I'm coming up here, so don't forget to give it to the clerk. Have you actually called law enforcement on occasion when Kathy made suicidal statements to you?
Yes.
All right. So you said you know of about 6 threats. What about actual attempts by Kathy to kill herself? Or was that the 6 and I misunderstood?
Those were the 6 attempts.
Okay. Can you describe some of those for the jury?
Yes. So the first one was, well, she was still married and she was very upset and she had overdosed on her trazodone. And she told me, I was in Key Largo and she lived in Key Largo at the time. And I said, I'm gonna have to take you in right now to emergency room. You're gonna die. And she said, no, I'm not going in.
Ms. Detman, it's okay. You don't have to give all of those
I'm
details.
sorry.
That's all right. I understand. So that was one attempt. What about other attempts that you're aware of?
So the second attempt was when she was in Port Charlotte. I had to go over the fence and open the sliding glass door. And she was in her bed, all dressed in black, and with a revolver in her hand.
And had she done anything with any medications that
Yes, she
time?
had overdosed on the oxycodone.
Did she end up going to the hospital that time?
Yes.
Any other attempts that you remember?
Yes. Yes, there was another attempt with oxycodone again about 4 months later. Then there was an attempt with medication and Everclear. The second attempt, she went back to the emergency room and was admitted vapoactive. The third time, when I called Port Charlotte Police, they got there and said, she appears fine to me. If she wants to drink in her own house, that there's nothing we can do. And then the most recent time was just in August of this year, August 21st. She called me and said she had overdosed on metoprolol, heart and blood pressure medication, because the other ones didn't work. So she said, I did that. And I said, have Colin take you to the ER. No, I don't want to go. Have Colin take you. Finally, I talked Colin into taking her to the emergency room.
So, to your knowledge, Colin was home when she overdosed and actually had to drive her to the
Yes.
emergency room in August of 2024.
Yes.
You mentioned that Kathy had been Baker acted. Was that more than one time?
Yes.
The jury has heard a lot about some things that Kathy claimed that were maybe not true. How would you describe Kathy's reliability or her reputation for truthfulness?
Objection, Your Honor.
Judge, can we go sidebar?
What was the objection? What was the question? Alongside her. Dang. Granny's getting tired. What did I do to deserve this help?
Forcing her to have a hysterectomy.
Uh-oh, this is gonna get sadder.
Her insurance company, cancer.
True, right?
Exactly.
So that's something that Kathy threatened and claimed, right?
Exactly. Yes. Yes.
Has she done that on other occasions? Make things up?
Yes. Yes. She made up that I was diagnosed with Lynch disease, which is it's an auto-recessive disorder where people have to have, they're more prone to cancer. So she said that her insurance company was forcing her to have a hysterectomy because of that. She also told Christy, and Christy was so distraught.
Okay, Ms. Detman,
I'm
I'm
sorry.
sorry. No, it's okay. I understand. So she made up that you had a disease that you do not in fact have.
No, I verified with my oncologist that I didn't have.
She also made up that John Paul Volantis had been neglecting his child, right?
Yes,
Has she ever made anything up about Robert Volantis?
yes.
What did she make up about Robert Volantis?
When she was younger, she said that Robert raped her.
And how do you know that that's not true?
It went to court, so I don't know. I only.
Did she ever tell you that she had made it up?
Oh, yes. Later, as an adult, she told me she had made that up.
Did she say why she made it up?
Yes, because she was mad at the situation between Robert and I.
Okay. Has she ever made anything up about her being responsible for everybody else's successes in the family?
Yes, she went as far to say that no one in the family would have any of their degrees, and that she, in fact, the only reason that I got my doctorate was because of her.
Okay. And did she actually make a threat to you regarding this
Yes,
belief
she
she
did.
had?
She said she was going to, when she was mad at me one time, she said she was going to contact the university where I work at, and I said, go right ahead. No, I had to.
What did she tell you she was going to?
She said
say
she's
to
going
them?
to call the university, my dean, and tell him that she did all of my coursework and that I didn't do anything and that I was a phony.
Did she make up at any time that you're aware of that Colin was failing school?
Yes, she said that he had been failing school and that when he was staying at my house, that it was my fault because I wasn't observing him on the computer to make sure he was doing his work.
Was Colin ever failing to your knowledge?
No,
When did Colin graduate from high school?
he graduated last June.
Was that actually ahead of schedule?
Yes, that was a year ahead of schedule.
And did he, in addition to graduating early, did he ever, did he get college credit?
Yes,
At the same time.
He was dually enrolled in college.
That's a complex to lie about people.
You mentioned earlier that you had paid for some trips, the trip for Kathy to go visit Robert Volantis and meet his mother.
Mhm.
Did you pay for other trips for Kathy?
Yes, the cruises that they went on, I paid for.
And the other trips that the jury has seen pictures of Kathy and Colin, who paid for all of those trips?
I did.
Did you also have, you mentioned points and using points for things.
That's our DVC, our Disney Vacation Club, as well as I have points through Hilton Honors.
Have you ever witnessed Kathy not being able to control her temper?
Yes,
Can you describe some of those
yes.
times?
She went at,
Your Honor, if we may approach for a moment. Another sidebar, the headset that Mr. Griffith is using is on mute somehow. I can't figure out how to unmute it.
Does it not have a,
It doesn't.
certain that it's plugged in?
It indicates that it's on mute. It has like a little, that's the one I've been using.
reputation for two instructions, one when the reputation is known and one when it's not, but it's offered to prove that the alleged victim acted in conformity with that reputation, which is, I need you to talk me through how you're doing that, or are you not using that?
No, I think it is relevant because the defense is that Kathy grabbed the knife in the house in Auburndale. And that fits with past instances where she pulled a gun on Colin, where she attacked Inaki with a baseball bat and said she was going to get a gun, where she pinned her then husband against the house with a car, that she stabbed her husband and burned him, and those were in front of Colin. And she has independent knowledge of those too. So those are the specific instances.
Judge, I have nothing further to elaborate on besides my objection in the hallway. And I object to anything that will be contrary to what Your Honor just read in the jury instructions, Your Honor. It might be I don't know, it might be a question by question journey to see what, if anything, is admissible or relevant based upon the application of the question asked by Ms. Thornhill, the jury instruction differentiating between, as Your Honor pointed out, the reputation or things that the defendant has to have been present for, have personal knowledge of, and Ms. Stedman, depending on how narrow, or maybe I should say how wide her answers are going to be.
As far as her reputation, it's my understanding that her reputation within the family was for being dangerous and violent, and people were scared of what she might do at any given moment. So I was going to ask about both.
While I understand the community for purposes of this type of reputation evidence may be narrower, you're still going to need to lay that predicate.
Sure.
This is a family of estrangement, after all, it seems. So
Because of her violence.
Well,
yeah.
But I don't know who's estranged from who else. So
Well, and it,
she needs to understand and know that family community.
Okay.
So
and even if somebody's not still a part of that community on this particular day, I mean, they all.
I'm not suggesting it has to be at some
Okay.
particular instant in time, but I haven't heard a lot about her closeness with others who may share that in that reputation or have knowledge of that reputation.
Okay. I will do my best. Is
And
this
we'll
our-
just take it question by question as Mr. Levine suggests.
Okay.
Do you want to go ahead and just take our mid-morning recess?
That's what I was gonna ask, if I could request.
Mr. Levine?
Yeah, that's fine, Judge.
All right, we'll take 10 minutes.
And of course, they're not back. And they said they were going to be back.
We're back on the record. Defendant is present with lawyers, state counsel is present. So ready for the jury?
Yes, sir.
All right.
is she? Is she still in the loop? Oh, there she is. Get a move on, people.
All rise, please.
Please be seated.
Ms. Detman, I'm going to ask you about some specific instances and may ask you to describe a little bit about them. So starting with, are you aware of Kathy having pinned her then husband to the wall of the house with her running car?
Yes, ma'am, I know.
Okay. And were you present for that?
No,
Have you ever, are you aware if Colin was aware of that incident?
yes,
He was aware.
yes.
What about an incident where Kathy stabbed her then husband with a corkscrew and then burned him with a terrarium light? Are you aware of that incident?
Yes, ma'am.
And are you aware that Colin was present for that incident?
Yes, ma'am.
Are you aware of Kathy threatening to kill her then ex-husband's girlfriend's family in Homestead?
Yes, I know.
Are you aware that she actually started driving toward their house to follow through on her plan?
Yes,
Did you actually speak with her on the phone then?
yes. I was telling her that what she was doing was crazy. She was going to get in trouble, that she couldn't take it out on 3 innocent lives in Homestead. She needed to turn around and go back home.
Are you aware if Colin was aware of that incident?
I'm not aware.
The incident where you said Kathy attacked your husband with a baseball bat.
Yes,
Are you aware if Colin was aware of that incident?
I'm not aware of that.
And have you ever personally witnessed Kathy engage in a physical act of violence towards Colin?
I know that there was a fight at the house in Port Charlotte, and beating him with a belt and making him do push-ups, sit-ups, push-ups, and then holding a weight above his head while he was running in place.
When you say that she beat him with a belt, were you actually there for
Yes,
that?
I was, and I tried to stop it.
Right.
For the belt when I was a kid.
What about, are you aware that Kathy pulled a gun on Colin?
Yes, and then later she said that she denied it. Then she said yes. She pulled out the gun and handed it to Colin and said, "Just kill me, shoot me."
So she actually admitted that to
Yes.
you.
Yes,
Colin was aware of that because he was the one who was present with her.
yes, and Corporal Rendos was aware of that also,
How was Corporal Rentus aware of this?
because he and I and Kathy were talking about that. There's a difference when you take a gun out and give it to somebody and say, "Here, kill me with this," versus somebody pulling a gun out and putting it to their head or to their chest.
And so Corporal Rentis was a part of this conversation where Kathy admitted she pulled a gun,
Yes.
and she said she handed it to Colin.
Yes.
Did she ever admit that she actually threatened to kill Colin with it?
No, she never did.
Within your family, we've talked about some of the family members. Despite some of the estrangements that Kathy had, would the family sort of maybe not talk to her for a while and then everybody would come back together, take trips together? I mean,
I was the constant in her life. My oldest daughter didn't talk with her while she was married.
okay, what I'm asking about is, did the family talk about Kathy with each other?
Yes.
And whether or not Kathy was estranged from anyone at any one particular moment, did the family continue to have discussions about Kathy?
Yes.
And was there, did Kathy have a reputation within your family as being violent?
Yes.
Did she have a reputation as being unpredictable
Yes.
and volatile?
Yes.
Despite all of this, did you still love Kathy?
Yes. Very much. Very much. I always.
It appears that Kathy at times wanted Colin with her at all costs, and then at other times wanted nothing to do with him.
Yes, when she had Colin back for about a month, she spoke with me and she said, "Mom, I have to get up every morning at 6 o'clock, take him to school, and then I have to go back and pick him up." And I said, "You don't have to, let him ride the bus."
Okay. I'm going to show you what's been marked as Defense Exhibit 26 for identification.
Sorry, what number is that?
26. Will you read this and see if you recognize it as a text from Kathy?
Yes.
And ask that Defense Exhibit number 26 be admitted into evidence.
Any objection?
No objection, Your Honor.
You received.
In this particular text, it's Kathy saying she's done with this. And she can't take Colin to school anymore.
Yes.
So that was a specific example of what you just described to the jury.
Yes.
As part of this vacillating back and forth that Kathy seemed to have about whether she wanted to have Colin live with her or didn't want Colin to live with her, did you all agree eventually to a concurrent custody plan?
Yes, we did.
And that was something, did anybody force Kathy to sign those papers?
No, not at all. Not at all.
Were there times when Kathy wanted to cancel the 751 plan, the concurrent custody plan?
Yes.
And then would she change her mind back?
Yes.
Okay, so it's safe to say she wasn't consistent.
She was not consistent.
obviously Kathy owned a gun, right?
Yes,
So at some point, did Kathy give her gun to you to have it out of the home in Fort Charlotte?
yes,
Do you remember when that was?
yes. It it's right after the incident where Officer Rentis and Lacey got involved when Colin came back to the home. So that must have been somewhere in the October timeframe of
Oh.
2023.
Okay. How long did you have the gun at your home and away from Kathy and Colin's house in Fort Charlotte?
Less than a week,
Okay. Why did you have it for less than a week?
because she demanded that I give it back. She said, "It's my gun, you can't have it." And I said, "But we discussed with Officer Rentis and Lacey that I would keep it." "No, it's my gun, you can't have it. And how do I know Nikki won't use it to kill you?"
Okay. So Kathy got the gun back, and
Yes.
so far as you know, she had it with her.
She had told me that she had given it to her next door neighbor, Melanie, for safekeeping. And then a couple months later, she said, "No, Mom, I lied to you. I've had it all along."
Okay. Finally, you had a lot of communication with Kathy on September 7th and September 8th,
Yes.
right? You also had communication with Colin during that time.
Yes.
Did you allow Colin to go to your house in Auburndale when Kathy kicked him out?
Yes.
And why did you allow that?
Because a child can't be just roaming around the street by himself. Colin told me he didn't have gas in his car. We had like half a tank, that was it. He didn't have his phone. He was using his computer somehow to talk with me. I told him, I said, "You have to get to Auburndale before dark, because otherwise the gates will be closed. During the day, the gates are open. And go in through the back sliding glass door, because there's no lock on the back sliding glass door. And I will be there Sunday. Don't talk to anybody and don't leave the house."
At some point, obviously, Kathy, as the jury's heard on some videos, was trying to find out if Colin was actually at your house.
Yes.
When did she finally discover that he was at your house?
I let her know around 11 that night.
On the 7th, so
Yes.
Saturday the 7th. And how did she react?
She said, "You lied to me." And I said, "I told you I didn't know if Colin was there." I said, "Because I don't want you going over there and grabbing him. You just threw him out. Give him some time, give you some time. Let's not have a huge problem associated with this."
And aside from conversations that the jury has heard between you and Kathy over the next hours, did you specifically tell Kathy not to go to your house in Auburndale?
Yes. I said, "I will be going Sunday morning." I left first thing Sunday morning. I was going to leave right then, but I was so tired and I have difficulty seeing in the dark that I thought, no, it's better that I wait. In hindsight, I should have gone. But so I waited. I talked to her. She said, "No, Mom, I'm going." And that's when she said, "I sold the car. They're going to come by and pick it up." I said, "You can't sell Colin's car. It's his car." "No, I don't care. I'm selling it. I'm turning it into his probation officer for not, because he's not allowed to leave the county." Which when I talked to the probation officer, I found that Kathy had told them that I had terminal cancer. So therefore, Colin could come and visit me anytime I want. I I had to tell the probation officer, well, right now, I'm only at stage 3, so I'm only in observation, but I'm not terminal.
Okay.
So,
But you personally told Kathy to not go to Auburndale.
yes, I told her, I said, let's get,
There's a loophole here, and I don't know why this went to trial. She has joint custody with Kathy, right? So that's his residence then. If he is a minor and she is his guardian, then her home is his residence. Therefore, stand your ground should apply. And they should be going for a self-defense judgment. Because he was staying at his guardian's home when she came in and went off on him.
when I get back, I will give him gas money and I will follow him there Monday morning. Let's just wait. Don't go there. You don't
Why-
have permission to go.
Why did you not want her to go to your house in Auburndale?
Because I didn't want her to start a fight with Colin. I was afraid that she would be combative, have a baseball bat, a gun.
I have any questions, I don't think.
Thank you.
Oops, sorry. I'm trying to move the. Dang it. I'm trying to move the closed caption. And I just.
Jury.
So far,
I was trying to move the closed captioning to the top.
Pulling a gun out and putting it to their head or to their. Yes, I am.
are you aware that she actually started driving toward their house?
Oh, we're past.
26. Has heard between you and Kathy.
Jail.
You-
No.
you
Just
prefer
talking
to
on the phone.
Sorry,
Talk-
guys.
your grandson here today. You never.
I thought I was doing something good.
Now,
Darn it. I was just trying to move the subtitles. Crud. No, don't move the whole freaking picture. Just there. Thank you. Just the subtitles. Even though they're wrong half the time.
but I need to ask you some questions, if that's all right with you. Cancer, Miss Stedman, I
Doesn't matter when it's all right.
know with the loss of your daughter and cancer and everything else, but I'm going to need to ask you some questions, if that's all right with you.
Yes, sir.
I would say that gives them an
Now, you've talked about that you were concerned that Kathy was going to attack your grandson, and then you listed a bunch of different weapons. But weren't you more concerned that your grandson, who had killed someone before and had been violent,
about time. It was going too good. Yeah. That should give him the out right there. I mean, that's probably not a legal basis, but everybody told her not to go. Nina, 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 you got what you deserved. I don't know. I have no idea. I guess it would depend on what age you're legally allowed to be left alone. Somebody told me in the state of Florida it was 6, and I don't think that's right. Who's going to leave a 6-year-old at home by themselves? I'm going to have to look that up. It would probably depend on the legal age you're allowed to leave your kids unattended. And I would think 17 would be okay. Because, like, what if you're home alone in your house, like your parents are going out to dinner or the movies or something, and you're a teenager and you have a test to study for and then you have to stay home, and then someone robs in to break your house. Breaks in to rob your house. What? You can't get a stand your ground because you killed an intruder when you're only 16 or 17? That wouldn't make sense. Of course, a lot of things that happen in Florida don't make sense. I'm gonna have to look that up. Come on, computer. Come on. Come on. Oh, now
Keep
I have
telling him, you have got to pray. You've got to read your Bible.
Now, I mean, this is an obvious question, but you love your grandson, correct?
Yes,
Your daughter is dead, clearly,
yes,
and she's not coming back, correct?
no,
Now, would you agree that you don't want to see the defendant have to go to prison for a very long time? Is that correct?
I don't want to see my grandson go to prison for something.
Well, you couldn't be more clear that your honor and all the answers that you've given have been driven by the defendant. Your grandson didn't murder your correct?
I am giving clear answers, sir, as to what happened. I know my daughter. That's why I didn't want her coming that day to the house without me being there. I wanted her to wait the next day so that maybe she could calm down a little bit.
You know your grandson too, correct?
Yes,
And you know his history, correct?
yes.
Now,
so sorry. I didn't realize it crashed again. I hope it wasn't out too long before I noticed. I was looking up the legal age. In Florida, there is no set age. I forgot what the agency was called. The federal child safety thing says under 12 is too young. 8 or 9-year-olds can stay by themselves for like half an hour if you have to go run an errand or something. But to leave them longer, for like any extended period of time, they have to be 12. But that's the like the federal guidelines. There is no lawful age in the state of Florida. But if I have an infant and I leave it alone and the cops find out, I'm pretty sure I'm going to jail. So I don't understand why there's not a legal age thing. Because, you know, what if a defense attorney is like, there's no law saying that you can't leave your baby home alone? I mean, I'm sure child neglect, they can find other things besides the age, but I don't like that. I think they need to set an age because somebody's going to wiggle out from that loophole one day, I bet you. It says whenever you think your kids are ready to be left by themselves. That's so stupid. But yeah, I was 12. I had a babysitter, and it was an older couple, I guess babysitters, and I had undiagnosed, well, it's still undiagnosed ADHD. And this old couple just couldn't handle me because I was just boom, boom, bouncing all over the place. And so my mom was just like, okay, you're going to stay home by yourself while I'm at work in the afternoons after school. So I was a latchkey kid. And like maybe, I don't even know, months. It wasn't even years. Because I was 12 and then we moved up here out in the country. So it wasn't for very long because my mom wouldn't have let it happen for very long because she was a helicopter parent like we've already talked about. But yeah, so nationally it's 12. In Florida, there is no age. And if I didn't back it up far enough, let me know because I was not paying attention. I apologize. Oh, I just share screen again. Dang it. I always want to just jump back into the trial and forget to push the right buttons. Oh, of course she knows her grandson. What kind of question is that? No. She's just there testifying because this some kid. God, makes sense.
Oh, you know your grandson too, correct?
Yes,
And you know his history, correct?
yes.
No.
Stop it, StreamYard.
I know the possibility of what could have happened. I know the facts about Kathy, having lived with her and worked with her, even to try to maintain her sanity, to try to maintain that she could keep her job as a teacher, to try to maintain that she wasn't trying to slice herself and kill herself.
Okay,
Not coming after my husband with a gun.
okay, let's talk a little bit more about Kathy. Now, it sounded like she had Now, you would probably agree that it didn't help that she got impregnated when she was just a child, correct?
She was 13. She got impregnated when she ran away from the Hope House, and they found her in the hotel with her boyfriend. It didn't help that her father called her F bitches and that she was damaged goods, and he didn't want anything to do with her.
Ma'am, it sounds like you're really quick to try.
No, not
you
at all.
didn't.
My dead daughter did the best that she could. We have a problem in this country with addressing mental health. We all know that. And that's what she had. She had mental health issues. At times, she was the greatest person on the world, very intelligent.
I appreciate that, man. I appreciate that. Now, your daughter worked as a teacher for many, many years, correct?
Yes, she did.
And her students loved her, correct?
Yes, they did, for the most part. I mean, as with any teachers, you're going to have some students that, I mean, I'm an educator myself. You're going to have some students that
Okay, can you guys hear me? Streamer, give us the sound back. Can you hear me? I unmuted myself. I don't know why it just decides to mute everything all of a sudden. I don't know whether to. Oh, wait, let me try this. I'm going to stop sharing and now reshare. I don't know why it does that. It'll just. A message will pop up that it's lost connection to my audio. It was getting juicy, y'all. And then there was an objection. I want to know the rest of that.
Husband, Chuck, correct?
yes.
And then, unfortunately for your daughter, this underage student is what it's believed to have happened, correct? And
Judge, I'm going to object to the relevance
Hear it
moments.
now?
sorry we have to talk about some unpleasant things, but it'll be over soon enough.
Thank you, sir.
No problem.
Yes,
Uh,
you were asking me why I was spilling dirt on my dead daughter, and I said, I'm not. I said, I supported her. I've gone into massive debt in trying to ensure
Okay, ma'am.
that she
I
had a.
appreciate that, but that was a few questions.
Oh,
But-
you're talking about how Kathy ran away from the Hope House and they found her in the,
No, I'm not talking about that either, but if you listen to my questions,
Just ask the question.
it'll get easier. So we were talking about your daughter, that she was a very committed teacher and very committed to the youth of her classroom. And I mentioned that at a certain point, she even allowed one of her students to move into the household, and it was believed that Chuck had an inappropriate relationship with this student. Are you aware of that? With a yes or no answer, if we can start at that place, I'd appreciate it. Are you aware of that?
yes,
And you were not a big fan of Chuck, as it ended up being the divorce, correct? For how he treated her, from how he impregnated her as a child through the years, being physically, emotionally, and mentally abusive to your daughter. I can't imagine you were a fan of that, were you?
no, Robert was the one that was a fan of Chuck.
Now, ma'am, I understand that you hate your ex-husband.
I don't hate him.
Well, it sounds like you're throwing stuff about Robert in a lot.
You just asked me if I was a fan, and I wanted to tell you who in the family was. I knew Chuck from the
Your
time
Honor.
he was.
Ms. Stedman,
I'm sorry.
that's the point. He gets to ask the
I'm
questions
sorry.
to elicit the information he's looking for. If additional information is needed, Ms. Thornhill or Mr. Hendry will make sure to address it. So just pay close attention to the question that's asked and try to answer just the question that's asked.
I apologize.
It's all right. Mr. Levine?
Appreciate it. Ms. Stetman, as it pertains to your last piece of information that you provided, as it pertains to your husband, he hated Chuck for what Chuck did to his daughter, that being impregnating a little girl, correct?
Robert thought about Chuck.
Sustained as to relevance.
All right, Ms. Detman, if I ask you a question that for your information, just please answer it, irrespective of your feelings about your ex-husband, all right? Now, at a certain point, Kathy got divorced from Chuck, correct?
Yes,
After years of unthinkable abuse, correct?
yes.
Now, let's move on to a different subject matter. When your grandson lived in Oklahoma with his dad for about 3 years or so, at the end of that, your grandson wanted to come live with Kathy and actually was able to, correct?
Yes,
And Kathy was very happy about that, correct?
yes,
And she felt that she had missed out, understandably so, on multiple years of her son's life, correct?
yes,
And she was trying to fix or make your grandson's life better.
she was trying to improve his lifestyle, yes.
Now, you mentioned you described it as a fight in Port Charlotte where law enforcement came because you said your daughter was beating Colin with
I did push-ups, and I took away above his head and running in place.
Okay, thanks for clarifying that. Now, you remember talking to law enforcement when they came out there, correct?
Yes,
And giving a sworn statement because you just wanted both parties, your grandson and your daughter, you wanted everybody to be safe and healthy and happy, correct?
yes,
Now, Ms. Detman, as to the root of what the issue was that night, do you remember telling the deputy that the three of you were at the dining room table, and Susan had Colin seated down, and Kathy told Colin that she would be implementing new parenting rules, and Colin would be having his Xbox, his cell phone, and other items taken away as disciplinary action due to him being disrespectful to her. Do you recall telling law enforcement that?
I remember telling law enforcement about the Xbox would be, I don't know if it was taken away, but it was going to be restricted.
And at that time, your grandson didn't want to hear from his mom, and so he stood up and threatened to fight her and said, "Let's just do it." Correct?
That was after the incident with the exercising and belt, the beating of the belt. That's when Kathy wanted us to all sit down, extreme to another, sit down and eat sandwiches. And then Colin got up from the table and said, "Let's just do it." And I went to go get my phone to contact Officer Rentis or Corporal Rentis or Officer Lacey.
Okay. All right. Very good. About how violent Kathy was. Is that right?
No, we didn't love to talk about how violent Kathy was. We talked about what we could do to help her to lose her job. We didn't want her to be suicidal. And more than anything, we wanted her to try to get better.
Did you talk about how violent your grandson was?
No.
Concerned about that?
Objection.
Now, you were concerned about where the defendant would live, correct? In terms of who he might hurt, whether he lived with you and your husband, Nikki, or if he lived with Kathy.
My husband did not want Colin to live with us because he said that if Colin lived with us, Kathy would be over at the house and he didn't want to have to deal with Kathy.
Ma'am, didn't Nikki say he didn't want Kathy, he didn't want Colin to live with them because he was afraid that Colin might kill you or kill him?
No.
All right, now let's move on to the subject matter of kitchen knives or butcher knives. Do you tell the jury about the time when you noticed that there was a knife missing from your residence there in Auburndale, and you were trying to figure out who stole the knife or who took the knife?
Yeah. There was a small knife with a blade like this that I bought in the dollar store, which is now like the $1.29 cover on it, and it wasn't in the drawer with the rest of the knives and silverware.
And did you find out eventually that your grandson had taken the knife?
Yes.
And he basically told you he just needed it just in case, and did not elaborate on what he was going to do with it?
He said he just needed it.
Now, at that time also, Kathy made it explicitly clear to you that she was afraid that the defendant might hurt her, correct?
Not at that time, it was later.
And there was multiple times when Kathy let you know that she was afraid for your safety and for her own safety.
Yes.
Now, you mentioned that a couple of things about the 7th and the 8th of September. You mentioned that Colin told you that he didn't have a phone with him on the 7th. Is that correct?
Yes.
Were you aware that he did have his cell phone with him and it was in his car?
So his cell phone had been turned off by his mother. She used to do that anytime she'd pick him out, she'd turn the cell phone off. In fact, it's in the records that she turned it off, and she turned it on, and she turned it off.
And you mentioned that the sliding door, that it had no lock on. Is that correct?
We had adapted the sliding door for a doggy door so Freddie could go in and out when he was staying in Auburndale, my acid hound. And so we did not have a locking mechanism. You could close the door, but you couldn't lock it.
And so that's how you mentioned that your grandson was able to get into your house on the 7th?
Oh, plus the front door was, I don't believe in locks. I've been burglarized and the burglars got in quicker than I could find my lock. I don't lock things.
Okay. Now, your response when this was going on, when law enforcement made contact with you, was that you didn't know that Colin was a psychopathic killer, correct?
I never said that. Never.
If I may approach, please, Your Honor. Of 67 of her statement on September 8th.
Let's see it before you approach.
Okay.
I wanted you to see what he's
Thank you.
referring to before you approach.
And if you could just take your time and read the highlighted portion to yourself.
For one thing, I don't use words like stupid, Colin. I would never say that.
Oh, man.
He just wants you to
Oh,
read it to
okay.
yourself.
Oh, I'm sorry. I'm sorry.
That's all right. That's all right.
We may need to go sidebar real quick.
Have you finished reading it?
Yes, uh-huh.
Approach sidebar, please.
I can't believe this woman doesn't lock her door in Polk County and a retirement community. Come on, the thieves know that's where the money is. Florida retirees are loaded. That's ridiculous. Oh, and Judy, remember, was it yesterday? I think, not yesterday. Yesterday was Monday. Friday. You said he was hiding behind his lawyers. It's the other way around. The lawyers are hiding him from the cameras. Yeah, it could be a well patrolled place. I think she did say it was. Didn't she say it was a gated community? I still think that a thief could get in a gated community if he wanted to bad enough, though. Or I should say, if they wanted to.
Miss Stedman, we're almost done. All right.
Thank you.
You're welcome. Miss Stedman, is it a fair statement that Kathy had expressed to you that she was getting very frustrated with the fact that your grandson wouldn't do his chores, was disrespectful, and was basically just taking his mom for granted?
Yes.
And when Kathy was communicating with you on September 7th and September 8th, that was the Saturday and the Sunday, she did so by both text messages as well as phone calls, correct?
Yes, sir.
And Kathy made it clear that she wanted your grandson by 10 a.m. on Sunday, correct?
Yes, sir.
And then when that didn't happen, when 10 a.m. came and went, she still made it clear that she wanted your grandson to come home, correct?
Yes.
And Kathy mentioned that she wanted him home. She wanted him to go get work at Domino's from like 4 or 4:30 to 8 or 8:30 on Sunday, correct?
Yes.
And your grandson was working at Domino's, correct?
Yes, he was.
And so Kathy wanted him home so he could then go to Domino's that night, correct?
Yes.
And then kind of towards the end of the communications, then Kathy told you she was going to your house to get Colin to come home, correct?
Yes.
And she told you that either he could go home with her or he could drive, basically follow her in his car, correct?
Yes.
All right. Thank you for your time today, Ms. Dedman.
I have no regret.
The witness released.
Yes, sir.
She released.
Yes, sir.
Thank you.
Thank you.
Any other witnesses or other evidence you wish to present?
No, sir. That's
Will there be any rebuttal, Mr. Lee?
No, Your Honor.
Ladies and gentlemen, both parties have rested their cases. The next phase would be closing arguments, followed by your instructions on the law and then deliberations. Closing arguments in these types of cases are typically not short. Also, I need to have a conference with the lawyers regarding the jury instructions, although it is up to me to decide what laws apply and how you should be instructed. They do have a right to give input. That conference could take some time. So if we did all of that in closing arguments, we would be sending you out probably mid to late afternoon. And I don't want to do that to you. So I'm going to give you an early day today. We are going to work the rest of the afternoon to get all of those strings tied up so that tomorrow morning we'll begin directly with closing arguments, and then the instructions will already be finalized, and you will be probably going to deliberations around lunchtime, I would imagine. So you're going to have an early day. Now, although you have heard all of the evidence, actually, I'm not quite sure about real quick. Our schedule, ladies and gentlemen. So before I dismiss you, I just need a few minutes with the lawyers outside your presence. So if you would just wait for us in the hallway for a moment.
All rise, please.
Did he do the thing where he asked Colin if he wants to testify and all that? Yeah, I'm kind of shocked that they already rested their case. Who else did they call? Did they just call? They just called his grandmother, right? That's it. somebody on another channel told me that DCF probably wouldn't be allowed to testify because.
Right, will it be the truth, the whole truth, and nothing but the truth?
Oh, here we go.
Yes, Your Honor.
All right. I did not ask you about whether or not you wanted to give testimony in this case, so I need to talk to you about that. I assume, based on your lawyer having rested, that you did not want to testify. Is that correct?
No, Your Honor.
That's not correct, or no, you did not want to testify?
I did not want to testify, Your Honor.
And have you talked about that with your lawyers today?
Yes,
Have you talked about it with them on more than one occasion?
several, yes.
And did they answer any questions you had about whether or not you should testify and address any concerns you had about doing one thing or the other?
Yes, Your Honor.
All right. And do you need any more time with them before you answer my question in a few minutes about whether this is your final decision? Do you need any more time with them?
Take a minute.
All right, so he can, Mr. Larson, if he can take them to the jury room.
47.
I thought we were doing the charging conference thing. Where'd they go? Are they taking a break first? Did I miss something? Lord knows I probably did. Hey, Melissa. I know. This, for what I thought was going to be a super long, convoluted trial, it has been awfully short.
Griffith, you've had just a few minutes, I assume, as long as you wanted to talk some more with your lawyers about this, correct?
Yes, Your Honor.
And did they answer any additional questions or concerns that you had?
They did, Your Honor.
Do you have any questions of me about your right to testify versus your right to remain silent?
No, Your Honor.
And it is your right to remain silent, and I'll be telling the jury that you're not to be concerned by that or view it as an admission of guilt. But one thing I need to make certain of is that you understand that this is your choice in this case. You understand that?
Yes, Your Honor.
There are many things your lawyers can do without your permission, things they can do that you disagree with, even things that you speak up and tell me you don't want them to do, but not this. You understand?
Yes, Your
Have they explained that to you, that no matter what they think, it's your decision?
Honor. Yes, Your Honor.
Now, they are supposed to give you some advice and counsel about what they think you should do. Are you satisfied with the advice and counsel they've given you?
I am.
And today, are you under the influence of anything, drugs, alcohol, or medicine?
No, Your Honor.
And any concerns related to competency? Have any of those arisen over the weekend, Mrs. Hornfeld?
None.
Mr. Henry?
No, Your Honor.
And has anyone, including either of your lawyers, promised you anything or threatened you to keep you off the witness stand?
No, Your Honor.
This is your choice and your choice alone,
I know, Your Honor.
is it?
Yes.
And you do not want to testify?
I do not.
Anything else you want on the record,
No, sir.
Mr. Henry?
No, Your Honor.
All right. Okay, we can have the jury. I find that your choice is freely, knowingly, and intelligently made, and that it's made upon the advice of competent counsel.
And Your Honor, we're not raising additional argument on judgment of acquittal, but we would maintain our previous motion.
All right. Same rule.
Why did they turn off the mic again? I am so tired of all the mic turning off. Like they don't want to hear, don't want us to hear half of what's going on. Yeah, Judy. Somebody told me last night that the DCF stuff wouldn't come, probably would not come in, especially because he's still a minor. Like I guess all that stuff gets sealed. But in this, I really don't think it should when his life is on the line. I mean, this kid is going to end up spending the rest of his life behind bars because he had a crazy mother. He didn't know which end was up. She was always making threats and stuff. Always. Threatened to call his school. Threatened to call his work. Threatened to take him out of college. This poor kid. I was at least expecting some kind of an expert witness about domestic violence or coercive abuse or something. All they brought as a defense was his grandmother. Oh, this poor, I mean, I know they only had 4 months, but they could have gotten at least one expert in 4 months. Oh, this poor kid. Why didn't he waive his right to a speedy trial? Wait, why is he standing? Is the jury coming back in for something? Did he bring them back in just to dismiss them for the day? What is happening? I swear. This trial is up, down, mic on, mic off, mic off, mic off. Like, I never know what they're doing.
All instructions that have been given so far will go back. We will start this morning with 2.3 stipulations. I have included the exact language from
Oh no, I don't want him to. I usually want to hear from him too, but no, not this time. I agree with you, Judy. Not this time. I'm not going to put your comment up because I don't want to crash StreamYard again. It might crash when I unpause it. But, yeah. Because if he gets flustered on cross, there's no telling what he might accidentally say. And he doesn't need to get tripped up over anything because I hate to say it, and I know it's wrong, but if he did do it, he had a reason to do it. He had a reason. And I think, I swear, she could have done it to herself, or she could have grabbed the knife first to threaten him with it. I would not put that past her because she did it with a pew-pew before. She could have done it with a knife. Why is there a weather alert in effect? It's like today. fog. That doesn't affect me because I stay home. Yeah, I wanted to hear from the brother too because I wanted to know if he caught the same kind of abuse. Because there is a thing where in some families only one kid gets the abuse. They have a favorite to pick on. Because my mom was that person in her family. My grandfather apparently did things to her that he didn't do to my other aunts. And she's blocked it out of her memory. She swears it didn't happen, but my other aunts, some of my other aunts knew that it happened. It could have happened accidentally. She could have fallen on it. He could absolutely be 100% telling the truth. And he could have been holding it when she fell. It could have been a total accident. The problem with that is that he's done it before. And that one was with a gun that he purposely shot because it was self-defense. Oh, and I looked up stand your ground for minors, and it does. You have to be related to the person that is being threatened. So, like, if you're at your relative's house, like your grandparents' house or whatever, visiting, and they get threatened and you do that, then stand your ground applies. Or like the example that I gave, like if your parents are gone and you're home alone and it's your house, you're rightfully there and you're not committing a crime where you are. So it's same for adults, basically. I mean, they're like, when it applies, there was like a list. When it applies, when it doesn't apply, basically, it's the same for adults. They made it sound like it's different, but it's not. You have to be related to the person that's you're in defense of. Yeah. Stupid. That means it's you're rightfully at the place because they're your relative. Yeah. Dumb.
There's a stipulation that you handed to me that I read in court as part of that instruction. Is there any objection to that? Mr. Levine?
No, Your Honor, thank you.
Ms. Thornhill?
No objection.
All right. That takes us to 2.7, closing argument. That appears to be standard. Is there any objection?
No, sir.
3.1, introduction to final instructions is standard. Is there any objection?
No, sir.
3.2, statement of the charge is standard and accurate. Is there any objection?
No, sir.
It seems like the substantive instructions on crimes are at the end, but they would come next. And we begin with 7.1, introduction to homicide. That is a standard instruction and states what appear to be the appropriate lessers.
Yes, Judge, hold on, let me get to it since I didn't reorder that. It does appear to be standard and accurate.
No objection.
No objection.
All right. 7.2, first degree premeditated murder. Appears to be the standard instruction. Is there any objection?
No, sir.
7.3, first degree felony murder. Appears to be standard. Is there any objection?
No, sir.
That takes us to 7.4. Well, after that, I would give when there were lesser included crimes or attempts. That is back up. Here, and again, it states second degree murder and manslaughter as the lessers.
Those are the category 1 lessers.
Any other lessers requested?
No, sir.
And then for kidnapping, false imprisonment.
Correct. Also a category 1 lesser.
Any other lessers requested as to kidnapping?
No, sir.
All right. All right, second degree murder appears to be the standard instruction. Is there any objection?
No, sir. There doesn't appear to be a manslaughter instruction in the packet.
I don't have it either. Let me pull it from the Florida Bar website. Give me just a moment.
No, not down here.
There goes the mic again. What is with this cord? And I get hiding him in a way, but every million times now.
We get there. Kidnapping also comes before when there are lesser included
Right.
crimes or attempts. Is there any objection to the kidnapping instruction as proposed?
No, sir.
All right.
I was so hopeful they would drop the kidnapping.
So since the state did not include 7.7 manslaughter, is the state asking to proceed on just manslaughter by act, element 2A?
Yes, sir.
Do you agree with that?
I do agree with that.
All right. So
They took the death penalty off the table, right?
it will read to prove the crime of manslaughter. The state must prove the following two elements beyond a reasonable doubt. Kathy Griffith is dead. Have you been putting her middle name in?
No, Your
And then I will take out the A, the letter A. Element 2 will simply read Colin Griffith intentionally committed an act or acts that caused the death of Kathy Griffith. And then the next paragraph, every person has a duty to act reasonably toward others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously explained to you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. And that's it, correct, Mr. Levine?
It is, and thanks for taking care of that, Judge.
Ms. Thornhill, you agree that's
I-
all they should be instructed on?
I do agree.
Just a moment.
Why? Is that like the camera mic or something switches to a different mic and you can tell when the sound quality changes. You can't hear like the background noise or something, and so everything gets quieter. I don't know what's going on. It's not on my end, it's on Long Prime's end. Or, yeah, Long Prime. I was looking for the Long Prime channel the other day and I typed in Law and Order and I got all these clips of Law and Order and I'm like,
Standard instruction, is there any objection?
No objection.
All right. Moving back up.
Judge, do you read excusable homicide and justifiable use of deadly force after the lessers or after introduction of homicide or?
Well, I generally read that after all lessers,
Got it.
unless you want it someplace else.
Nope.
Mr. Levine?
I'm fine with whatever the defense requests, Your Honor.
So that would come next. And let me pull up that instruction. I had it up somewhere, I think, this morning. Right, that is 3.6F. And this was proposed by the defense, but it's got the whole kitchen sink in, so we need to talk about that.
Yep.
Just
justifiable homicide. That's what I would vote for if I was on the jury. But I don't know.
so it should, the title should just be justifiable use of deadly force, correct?
Correct.
Justifiable abuse of
It
deadly
is a
force?
defense, you're claiming self-defense only as to count one, correct?
The first degree murder, yes.
It is a defense to the crime of first degree murder if the actions of Colin Griffith constitute the justifiable use of deadly force. Deadly force means force likely to cause death or great bodily harm.
Oh,
Great bodily
justifiable
harm means
use,
great.
not
It's distinguished from slight, trivial, minor. or
Stop it, StreamYard. Stop, StreamYard. Okay, guys, it's most likely fixing to crash again. Just warning you. Yeah, justifiable homicide. Oh, would you look at that? I'm psychic now. kidnapping. If he had like brought her inside and tied her to a chair or something, maybe. But not the kidnapping. But justifiable homicide. Yeah. The only reason why it would be felony murder would be if they said guilty on the kidnapping. That would be what would make it a felony murder. And I don't see how that's kidnapping. She went over there. She had already been inside the house.
Reasonably believed that such force harm, correct?
Correct.
And you are not requesting or the imminent commission of some applicable force.
No, because the applicable forcible felony would be aggravated battery, which indicates death or great bodily harm, so I think it's unnecessary.
Is there any dispute about duty to retreat and which instruction I give on that, Mr. Levine? There's either
Thursday, guys. Thursday. Put a post-it note on my computer where it says share screen in big letters so I don't forget. Come on, StreamYard. Thank you.
to the paragraph which reads Colin Griffith was using deadly force if he reasonably believed himself or others. But then this next section encompasses the same context, but or the same law, but in the context of stand your ground. I don't think both need to be given, but is this what you're requesting, or just the simple to prevent?
I mean, I would rather have both, just in case the jury thinks that he didn't have a right to stand his ground in this house that he had a right to be in. I realize it's somewhat duplicative, but it's the standard and that's what is allowed for. It doesn't say give
Right.
this or this.
Mr. Levine?
No objection.
So the next part we'll read. Colin Griffith was in you want dwelling or residence?
Residence is fine.
Was in a residence in which he had a right to be.
Good, I'm glad.
He had no duty to retreat and had the right to stand his ground and use
I was right. Y'all,
force.
Look at me
including
learning
deadly
legal
force,
stuff.
if he reasonably believed imminent death or great bodily harm to himself.
That's correct, and B is not requested.
The next section is not applicable, correct? Or are you asking for that? The use of deadly force is justifiable if defendant reasonably believed the force was necessary. I'm sorry. Yes. To prevent great bodily harm to himself while resisting any attempt to murder him, commit a forcible felony, or commit a felony upon him, or commit a felony upon or in a dwelling in which he was present. Are you asking for any of that?
Well, I mean, once again, Judge, it seems duplicative, but since it's not in the disjunct, and it's entirely possible the jury could believe that Kathy was trying to murder Colin, I would request it.
Mr. Levine?
No objection.
Yes.
Colin Griffith reasonably believed that the force was necessary to prevent imminent death or great bodily harm to himself while resisting any attempt to murder him or commit an aggravated battery upon him.
Yeah, can we also add aggravated assault?
Griffith reasonably believed that the force was necessary to prevent imminent death or great bodily harm, attempt to aggravated assault.
No objection.
But the last paragraph you're not asking for.
No, C,
This next part about law enforcement and excessive force is not applicable. You agree?
I agree.
Now, in deciding whether Colin Griffith was justified in the use of deadly force, you must consider the circumstances. Deadly force. A reasonably cautious and prudent person under the same circumstances would have believed the use of force, of deadly force, excuse me, was necessary. Right, this next portion about presumption of fear is not applicable, correct?
I don't think it's applicable, Judge.
And nor is the next portion of those A through D paragraphs, correct?
I agree.
Nothing about presumption of intent to commit an unlawful act, agreed,
I agree. That is not applicable.
since we haven't chosen.
Right, I think
Do you agree,
residence.
Mr. Williams?
No objection.
I do not need to define vehicle, correct?
Correct.
All right. And then there's this part. However, the use of deadly force is not justified if you find that Colin Griffith was attempting to committing or escaping after the commission of an applicable forcible felony. Am I getting that?
I am not.
Yes, sir.
Okay.
Or kidnapping, correct?
Yes, sir.
Is there an objection?
No.
All right. is not justified,
I don't think that,
I don't know that that applies, does it, Mr. Levine?
No objection.
All right, so that whole section comes out. All right, and then I'm assuming you want prior threats or difficulties.
yes, please.
So that would be if you find that Colin Griffith, who, because of prior threats or difficulties with Kathy Griffith, had reasonable grounds to believe that he was in danger of death or great bodily harm at the hands of Kathy Griffith. You may consider this fact in determining whether the actions of Colin Griffith were those of a reasonable person. If you find that at the time of the alleged first degree alleged first degree murder, should it also say the lessers?
As with a previous section in the same instruction, it could say first degree murder and all included lessers.
If you find that at the time of the alleged first degree murder or any lesser included offense, Colin Griffith knew that Kathy Griffith.
And Judge, I'm sorry to interrupt. The state's proposed instructions uses Catherine Griffith, so we should probably be consistent throughout.
All
I'm
right,
sorry.
I'll make that
Yep.
change
Got it.
before I finalize it. Thank you for that. Catherine Griffith had committed an act or acts of violence. You may consider that fact in determining whether Colin Griffith reasonably believed it was necessary for him to use deadly force. All right, as to these two reputations, are you asking for one or both?
Both, please.
Mr. Levine?
No objection.
All right. If you find that Catherine Griffith had a reputation of being a violent and dangerous person, and that her reputation was known to Colin Griffith, you may consider this fact in determining whether the actions of Colin Griffith were those of a reasonable person in dealing with an individual of that reputation. If you find that Catherine Griffith had a reputation of being a violent and dangerous person, you may consider this fact in determining whether she was the initial aggressor. Then, in considering the issue of self-defense, you may take into account the relative physical abilities and capacities of Colin Griffith and Catherine Griffith. And that is it, correct?
Yes.
Any other comments, requests, suggestions with respect to justifiable use of deadly force?
No, sir.
All right.
And one quick question, is it my understanding that all the proposed subsections of justifiable use of deadly force have come from the standard jury instruction. There's no special request by the defense.
No special requests.
Everything, what was sent to me by Ms. Thornhill appeared to be directly copied from the Florida Bar website. So,
Yes, it was.
all right. Moving back up.
So then would excusable homicide follow that?
Are you talking about introduction of homicide?
That there was actually an excusable homicide instruction that was provided in the packet that the state,
Where is that?
I don't remember where it is.
Inside the introduction to homicide portion, I'd have to scroll down to confirm, but
I didn't see that in the copy. I mean,
You're right.
excusable homicide is included in the introduction.
The explanation of what the circumstances are under which it would be excusable.
It was an incomplete instruction. I have the killing of a human being is excusable and therefore lawful under any one of the following three circumstances. When the killing is committed by accident or misfortune, when doing any lawful act by lawful means with usual ordinary caution without any unlawful intent, or two, when the killing occurs by accident and misfortune in a heat of passion, upon any sudden and sufficient provocation, or three, same thing, if a dangerous weapon is not used and the killing is not done in a cruel and unusual.
Yeah, that's what I'm requesting, and maybe it just is
I
part
think what
of
it is-
introduction to homicide, it just,
I think what it was is, because the standard instruction has the two sections, justifiable and excusable, and they're all caps in the standard instruction, and probably what happened is
just
it
second
went
page.
to a second page. But
Got
that's in there. All right. All right, after self-defense, are there any aggravator instructions that need to be given for weapons or anything like that? I didn't see any.
Your Honor, I think in the verdict form, there's special findings, and you're right, there should be an aggravator as it pertains to the knife and the weapon, but I don't believe that I remember to include it.
That would be aggravation by carrying, displaying, using, threatening to use, attempting to use a weapon. And was that charged in the indictment?
Yes, sir.
Yes. Sure.
Just to count one, I believe.
Yes.
So that is 3.3A.
I'm sorry?
That's 3.3A. Do you object to that instruction being given?
No.
Let's hammer that one out. But all right, so that will read it will be aggravation of, now, Mr. Levine, had this first degree murder.
Yes, sir.
Correct, because it's a level enhancement, correct, not an.
Correct.
And for manslaughter, correct?
That's acceptable.
You agree, Ms. Thornhill?
Yes.
By carrying, displaying, using, threatening to use, or attempting to use a weapon. And I will read, if you find that Colin Griffith committed second murder or manslaughter, and you also find beyond a reasonable doubt that during the crime, carried, used, or attempted to use a weapon, you should find first degree murder with a weapon. I don't need to define firearm.
That is correct.
Object readily capable of inflicting bodily harm if used in the ordinary manner contemplated by its design and construction, or to any other object. Do I need to do any other object?
No, I think it's,
Pretty clear.
yeah, we're
Do you
doing
agree,
it tonight.
Mr. Levine?
I agree.
All right. Then the final paragraph, so I'll take out the one as well, so it will just be one sentence. Committed second degree murder or manslaughter, but you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, or attempted to use a weapon, then you should find him guilty only of second degree murder or manslaughter, correct?
Yes.
Yes.
All right. There is no instruction on the issue related to juveniles. That's just a verdict form issue, correct? For the findings of
Actually,
actually killed, intended to kill, or attempted to kill, correct?
yes, I agree.
All right, so that will take us then to 3.7, plea of not guilty, reasonable doubt, proof. This is the new standard instruction, I believe, correct?
That I don't know.
Well, it may not be, and I thought, because I've been giving this instruction by memory probably 15 years, but I never noticed until recently that first sentence of what a reasonable doubt is not. I never remembered does not mean proof beyond all doubt. I thought it just started with a reasonable doubt is not a mere possible doubt. So I think this is new. Any objection?
No.
All right. The most current version on the website.
That was my intent, Your Honor.
All right, let me look just to be doubly sure.
In my office, I wouldn't say it was necessarily pulled from the website, but pulled from our computer that is supposed to be the most up-to-date jury instructions originated from the website.
And that, it's in there. It's on the website. That doesn't appear to be new standard language. Oh, yes, it was amended May 2024. All right. Any objection to reasonable doubt?
No.
3.9, weighing the evidence. As to the, this appears to be standard, as to the factors for consideration 1 through 5 are always given. Do we need money or preferred treatment?
I don't believe so, Judge.
Mr. Levine,
I agree.
pressure or threat?
I don't believe that's applicable here.
Mr. Levine,
I agree.
I will give inconsistent statements. Is that agreed?
Sure.
Mr. Levine,
Yes, sir.
there's no felony or misdemeanor conviction, correct?
Correct.
And no reputation for truthfulness, correct?
Correct.
Do you agree, Mr. Levine?
I agree.
All right, so I'll renumber inconsistent statements as number 6. All right, the rest is standard, including expert witnesses. I will remove the defendant becoming a witness,
Yes, please.
and the rest appears appropriate. Agreed?
Yes.
Yes.
Do you want me to give 3.9A defendant not testifying?
Yes, please.
And am I giving 3.9B defendant statements?
Yes, please.
Standard, is there any objection?
No objection.
Three point one, cautionary instruction is standard, any objection?
No objection.
3.12, verdict.
I would object if I thought it would do any good to, you don't have to be unanimous on the premeditation or the felony murder. But I don't think I have.
You're making a record preservation
Yes.
objection?
I am making a record for preservation purposes.
Do you wish to make an argument?
Just that I think that the unanimity requirement should apply to the different theories that the state, that the instruction should be, your verdict must be unanimous either as to premeditation or unanimous as to felony murder.
Response, Mr. Levine?
No, Your Honor, I would ask that you instruct the jury on the standard jury instruction.
Law, as I understand, has not changed, and that under Florida law, they do not have to be unanimous as to the type of first degree murder, only that it be one or the other. I think this should go before the paragraph above it.
Yes, yes, it should.
Do you agree, Mr. Levine, that the last paragraph should go above the second to last paragraph?
Wherever it's supposed to go, Your Honor.
All right, so that's where I'm going to put it, and you agree with that?
That's fine.
We'll talk about the verdict form in just a second. Single defendant, multiple counts, I'm taking out for information in the title. But that appears to be standard and includes the caveat for legally interlocking counts. Any objection?
No objection.
That takes us to legally interlocking counts. Now, if I remember correctly, the last paragraph is not standard, but it's something that has been used before, so this is sort of a special instruction.
If I remember correctly, yes, I believe in these cases, maybe even Your Honor, proposed it or gave the parties an option, and it seemed to make good sense and describe everything clearly and accurately. If the defense has any objection to something, I don't object to if they want something taken out. That's beyond the standard.
So Ms. Thornhill, the first two paragraphs appear to be standard and accurate. That last paragraph reads, however, the alternative crime of first-degree premeditated murder charged in count 1 is not linked to any other count in the indictment. A finding of guilty or not guilty as to count 2 must not affect your verdict as to the first-degree premeditated murder charged in count 1.
I think that's an accurate statement of the law. I don't have an objection to it being read, even though it's not part of the standard instruction. It might actually help them figure things out if they actually notice that one is felony murder and one is premeditated murder.
So as to the rest of that instruction, any objections?
No.
All right. And that takes us to 3.13, submitting case to jury, which is standard. Is there any objection?
No objection.
And an instructional discharge.
No objection.
All right, are there any other, before we talk about the verdict form, any other standard or special instructions requested by the state,
No, Your Honor.
by the defense?
I'm sorry, hold on. I'm sorry, Judge, what was
Any other standard or special instructions requested?
No.
All right. Let's take a look at the verdict form. Here is the verdict. All right. And so as to count 1, the first choice is for first degree murder as charged in the indictment. Second choice, that is guilty of second degree murder, a lesser included offense. And under that, the further findings, and then manslaughter, which does not have the further findings. So my thought is we separate the verdict form into guilt findings and then special findings separately, since it would become repetitive if after second degree murder and manslaughter, they're in the same section of special findings. Does that sound fair, Mr. Levine?
It does, Your Honor, and I would ask that you add the language under manslaughter that's there for second degree murder, the special findings. It was
Display.
I didn't put it on there as an oversight.
I think that also the finding as to actually killing, well, you've only proposed that they be asked about actually killing Catherine Griffith. You don't really need any of the attempted to kill or intended to kill language.
Yeah, by operation of the facts of this case, I'm okay with it just saying actually killed.
That's fine.
All right,
But I,
go ahead.
because he is a juvenile, and that's what those special findings pertain to, would you put it under after the guilt findings, then do that as a further finding? That's what
Yes,
you were
it would.
indicating. Okay.
So we would basically have count 1 and count 2. It would be in count 1 in order first degree murder, second degree murder, manslaughter, not guilty. And then count 2, kidnapping, false imprisonment, not guilty. Then special finding question 1, if you found the defendant guilty of first degree murder or second degree murder, you must answer the following question. The defendant actually killed Kathy Griffith? Yes, no. And I explained when I'm going over the verdict form, that those also have to be beyond a reasonable doubt and unanimous findings. And then, so that's special finding 1. Special finding 2, if you found the defendant guilty of second-degree murder or manslaughter, you must answer the following question: the defendant carried, displayed, etc. Yes or no?
That makes a lot of sense.
Mr. Levine?
Yes, sir.
So I'm not gonna pound through that here while you're sitting in front of me. I'll just correct it.
Thank
And email everything to you all this afternoon, so you have it. And if you see any errors today, it's invariably, as I'm reading the instructions, I see one, but I would ask that you review them, and if you see any typos or other errors, to just alert me by email so they can be changed before they're printed tomorrow morning.
Yes, sir.
Is there anything else we need to take up?
I don't believe so.
I told jury they'd probably be going to deliberate around lunch. Are you anticipating all-day arguments?
No, Your Honor, I think they will be deliberating by lunch.
I agree.
All right, everybody enjoy the rest of your day. I'll see you at 8:30.
All right.
Okay, guys. Okay. 9 o'clock tomorrow. And I guess tomorrow will be the last day. How long do you think they're gonna be deliberating on this one, y'all? I don't think this one's gonna be a quick one. I think this one's gonna take them a while. Because you got, if they're anything like me, you've got law versus emotions in this one. Also got a lot of supposition that you can't depend on because nobody knows what happened. So just the two of them. He says she fell on the knife. No idea. I don't know. I think she's crazy or was crazy. I do think that, and I feel so sorry for this kid. And the thing that bothers me is that he killed his dad year before. He might have had a good reason to kill both of them, though. Who knows? It does. It requires supposition, and that's yeah, too much guesswork involved. And I don't like cases with too much guesswork involved. That's why I said they should have had well, I don't know. I was going to say they should have had a stand your ground hearing, maybe, and not brought the case to trial. But the stand your ground hearing probably would have ended up with the same thing going to trial. I mean, look at Ashley Benefield. She didn't win her stand your ground hearing, and I don't think she should be in jail now. So, a lot of people, unfortunately, I think too many people think if it goes to trial, that means you're guilty. And that's not always the case. So, there's been a few I've been pleasantly surprised about. Like, well, when I watched the Rittenhouse trial, it was done and over with, and I watched it because everybody kept talking about the Rittenhouse trial because it was kind of like the birth of LawTube, wasn't it? Like I kept hearing everybody say, back when Rittenhouse, back when Rittenhouse, back when Rittenhouse. And I'm like, I didn't watch Rittenhouse. I don't know what you guys are talking about. So I watched Rittenhouse. And I knew that he was found not guilty. You know, that they said it was self-defense. But to watch that trial, I was so thankful for that kid that they found him not guilty, because that was one that I wouldn't have called it that way. And the thing that I got hung up on that one was, would it have happened if he hadn't had the gun? Right? Because, like, maybe if he hadn't had a gun, he wouldn't have got attacked in the first place. But because he had the gun, he had to act in self-defense. So I don't like trials like that. So, and this is kind of like, if she had listened to people and had not gone over there, if he had done his chores, there's too many ifs. And we don't know what happened because there was nobody there. And the stories from the witnesses don't really match the story that the prosecution told. It was similar, but it was so, what's the word I want? Watered down compared to the way the prosecutor told it. Oh, that's right, Judy. Well, you know, if you can get texts on the cruise, I can text you the verdict. If you want to know just the verdict, unless you actually want to watch it. But I think you have to pay. Well, texting, you would have to, because Kristen went on a cruise, her 10-year class reunion. God, I can't believe I have a kid old enough to go to their 10-year high school reunion. She had to pay extra for like the international Wi-Fi or whatever, and she didn't pay extra for it. So she couldn't like text or message me on Facebook or anything like that while she was gone. But she could send pictures. So maybe it was international calling she didn't do. Or it was limited or something. But she couldn't text me. But she could send pictures. I don't know. There's something that you can get, but you have to pay extra for it. So you can still communicate. But you'll be in Florida Thursday and Friday, right? Won't you still be in Florida? I don't know. I have your itinerary. So maybe you'll still be in Florida when the verdict comes back. And then on the 6th and 7th is Karen Reed hearings. Maybe not the 7th. She said the 7th if they need it. But the 6th, and that's the day that is that the day the ship leaves, or the day that you have to be there? I've got your itinerary. I'll look. And then I think that's it. All that I know of. So you shouldn't miss. You shouldn't miss much. And then the trial is not. And then there's stuff in March. You'll be back by then. And then the trial's April 1st. And then my new internet Thursday. Hopefully, they should be able to find me, right? Because it's through the electric company, and they have to come out here to read my meter, so they know where I live, right? There shouldn't be a I can't find you problem. Hopefully. I'm so sick of people not being able to find my house. And what was it the other day? Oh, when we were going to do our pictures at the state park the other day, there was a limb down over the road again, and we had to go through the private property that belongs to the dairy, which the dairy doesn't mind because we've lived here for 30 years and we have a relationship with the dairy, but we're not supposed to. I mean, I know they don't mind, but it's private property. We're not supposed to be using their road. It ticks me off. Okay, 9:00 in the morning. Closing statements. Wow, they got finished faster than they said, because they said Wednesday. So closing statements are on Tuesday. Alrighty, guys. I hate this part because I don't ever want to leave. But I don't have anything else. I got most of the pictures back and I wanted to show you, but when I use StreamYard sucks because I can show you pictures if I use Firefox. I can't show you pictures on Chrome. But I can't stream on Firefox. I have to stream using Chrome. StreamYard, get it together. Fix it where you can do everything in one browser. It's ridiculous. They have upgraded and done some nice things, but there's other things they need to work on. That's one of the things they need to work on. And hopefully when I get better internet, I can enjoy some of the new features that they've added. But right now, anytime I try to do anything different, oh my God. You are kidding me. That is ridiculous. But you know what? It's just like buying food at a theme park. It's like you're there. You're stuck there. You're not going to leave. You're not going to fight the crowds and the parking and everything to leave to go to an outside restaurant like McDonald's. It's going to be way cheaper than the theme park. So you're going to pay double or triple what you would pay at an outside restaurant, and it's going to be worse food, quality wise. But like you're stuck there. They know you're not going to go someplace else. It's like it's marketing. Sometimes I'm like, I should have gone into marketing because of all these clever ideas for marketing that yeah. And I would love to drive down there and see you, but I'm grounded. Gainesville is as far as I'm allowed to drive because I don't remember how long ago this was. It was last year, towards the end of the year. I had gone to town for something, and on the way back, my car felt weird, and I couldn't figure out what was wrong with it. And so I told Travis, I'm like, I don't know what's going on with my car, but on the drive home, it felt weird. And so I was like, I don't know. It felt like something were in the back. I don't know if it's my shocks or what's going on. I don't know. It feels weird. It didn't feel like a flat tire. It wasn't like a blowout or anything like that. But apparently I had a slow leak in one of my back tires and I didn't realize it. I just knew something felt off. So he's looking at my car and he's testing the shocks in the back. He's like pushing down and he's like, it's your shocks. And then he looks down and he realizes I have a flat tire. So he looked at both tires and they both were almost, well, the one was like gone and the other one was fixing to go. So we changed the back tires and then he looked at the front. He's like, you need the front tire changed too. But we just did the back because right now that's all we can afford. And then I wanted to go to the Sarah Boone Trail and he's like, you can't drive it that far. You need new tires before you drive it that far. We've got to change the front tires before you can go anywhere. Great. So I can't go down there and meet you because you can't afford new tires. So we've had, let's see, the water pump went out on the truck, we had to replace. The tires on my car, we had to replace. And now we need to replace the front ones. We had to buy a new washing machine because it died. The AC died. We still haven't replaced that because that's over $8,000. And then we had termites. I think that's it. I hope that's it. I don't need any more. Really, really don't. I really don't. Please, Lord, no more. No more. No more. No more. I cannot handle anymore. I can't. Y'all pray for me. This is like, all of this has been within like the last 6 months. I can't take it anymore. Cannot take it anymore. And then on the 26th, I am getting my nerve block, my nerve ablation, where they go in there and burn the nerves. And I hope that's successful. And with everything else going on, I'm kind of afraid now. Just pray that my doctor's hands are steady. Okay, guys. Bye. I love you. 9 o'clock. I started at 9:30 this morning, didn't I? 9 o'clock in the morning, closing statements, and I will see you then. Have a good day. Bye.